Ladies and gentlemen, for your information, 4 members wish to speak on this bill. Representative Bradley, please state your purpose.
Speak on the bill.
The gentleman is recognized to speak on the bill.
Thank you, Mr. Speaker. I rise to oppose House Bill 483, expanding the list of felonies for which suspects can be compelled to produce DNA upon arrest. There is a certain bedrock principle of liberty in our society which holds the individual inviolate and presumed innocent. During the drafting of the U.S. Constitution, it was understood that the need to violate an individual's right to life, liberty, and property would arise during the course of investigating serious crimes, and thus the Fourth and Fifth Amendments were adopted, laying out the procedures for legally doing so by court order and with due process. According to the Fourth Amendment, all American citizens are guaranteed the right to be secure in their persons and possessions except by judicial warrant that has been sworn upon affidavit detailing the person and possessions to be taken, and no American may be so deprived except by due process. If a person can be compelled to produce a DNA sample, then they are not secure in their persons. If a person can be compelled to produce a DNA sample without a judicial warrant, then we as a state stand in violation of the U.S. Constitution. And for those who may be great at the 14th Amendment, we don't even have to rely on that either. The North Carolina State Constitution lays it out in principles in Article 1, Section 19, Section 20, and Section 35. A frequent recurrence to fundamental principles. Is there really any doubt as to the Founders' intentions when drafting the Fourth and Fifth Amendments? It was not to protect the popular but the unpopular. The state is trying to shoot an azimuth, but the plumb bob is out of order. I see no valid reason to compel DNA without a warrant. If they can get an arrest warrant, then they can surely get a warrant for DNA as well. I might even be able to sign off on this law if it were judicial guidelines for issuing warrants for DNA. I totally support collecting DNA by judicial warrant. If the facts of the case and the sworn affidavit lead the judge to believe that there is probable cause to compel DNA for an investigation, then issue it at the same time as the arrest warrant. We are after John Doe, who we believe murdered some child. You issue the arrest warrant and the DNA warrant at the same time. That's due process. Compelling DNA without a warrant is not due process. I believe we need to have our recurrence to fundamental principles. And that being so, I'll ask my colleagues to start by voting no on House Bill 483.